That girl Henny. Y'all gotta go to her channel.
The girl Henny, do you know who she is?
She a blogger or something?
Yeah.
Yeah.
I'm just like, where did this lady come from?
Girl been on your ass.
She on your life, G.
Shout out to Henny over there.
Hey y'all, welcome back to the bar. And if you are new here, please be sure that you like, comment, and subscribe. Click that notification bell, select all so that you get notified whenever I do a video. And if you are a returning Mob Down Henny Gang member, yeah. Now let's get into this content. Now, if you are joining us over here from IG, then you are about to miss all the hot Henny that I'm about to pour up, because tonight, I know that we have been watching all of the buffoonery and the buffoonery that's been going on in these internet streets. But tonight, I am going to be bringing you an update on Jay and Buzbee. I'm also going to be bringing you an update on Wack and Ray J's Federal Hacking / Rico case, baby. I'm also going to be giving you, who else we got? Jay-Z and Buzbee, Wack and Ray J, DJ Akademics. We're going to see what's going on with his essay cases, since he out here liking to pop his gums the way he be popping his gums, sitting around smelling like sat. And I'm going to give y'all what is the most requested court docs of them all, which is Blueface's update on all of his civil cases. Because y'all know, bruh man is already in the hole for a couple $1 million. We're going to get into all of that hot Henny in just a few minutes. But if you are still over on IG watching, what are you doing? Come over to YouTube. Get to the bar so you could kick off your shoes and relax your feet. Get comfy, sipping up with Henny. We kicking it, just kicking it. And this live is about to self-destruct in 5, 4, 3, 2, 1. All right, y'all. So now that the hootie-hoo has been put out there on, I'm so upset that y'all can't see my hair in its full glory. Maybe I should take the background down so y'all can see the hair. No, because then y'all gonna see inside the house. Anyway, so y'all, just like I said, we're gonna get into all of this hot Henny. And the first one that we are going to get into, let me see who I want to get into first, because we got a lot of hot Henny to talk about. I guess we're gonna get into the Jay-Z and the Buzbee case, so we can hurry up and get that one done and over with, because yeah, I guess we gonna go there. All right, so hold on. I know, I got it. I'm about to put the watermark up, okay? Give me moments, because there has been an update, and baby, let me tell you this. The judge in this case is not trying to hear it. They are calling Alex Spiro out on everything, okay? Shout out to all of y'all throwing them Henny glasses in the chat. I see y'all. Yes. So, to give y'all a little bit of a rewind, let's recap on the last Jay-Z and Buzbee feud in the court docs that was going on in my last video. And we're going to stop. I did it again, y'all. I did it again. Oops, I did it again. I played with your heart. Okay, I got it. Why is it not? Why is it not showing on my end? Do y'all see a video? Let me see if y'all seeing a video over on y'all side. I know y'all didn't hear nothing, but I don't even see y'all seeing the video. I'm sitting here watching the video. Are y'all watching the video? Why I get hit with a commercial going into my own live? I know y'all didn't. No, y'all are not seeing a video. What the heck is going on? Do y'all see a video? No, they don't see a video, Henny. Damn it. Stop asking. So we're going to stop sharing for a second. Let me see if I can get y'all the video up that I was just playing. Oh, Migo, you making it seem like, oh, it is the video. I'm sitting here looking and all I see is a court doc. So I'm thinking y'all not seeing the video, but I'm forgetting that this is the video because there goes me. Okay, so let me move myself. Let me do it like this so y'all can see the video. Okay, all right, here we go. Here we go. Attorneys Marcy Croft and Emmanuel Quinn are orchestrating the efforts. In some cases, defendants' agents pretended to work for the state of Texas. Do y'all hear this? And have flashed fake badges. Soliciting clients is a crime in the state of Texas. Paying individuals to file false claims is unethical and criminal in the state of Texas. Impersonating a state official is a crime. In at least one case, defendants agents offered as much as $10,000. Okay, this is the last case, to a former client of the Buzbee law firm to sue the firm. Unfortunately for the defendants, their agents were not very smart. Okay, and that's where I left off at. So when we last left off on the Jay-Z Buzbee firm, as y'all just heard, a beef that's been going on, they were out there in the state of Texas, okay, and they were trying to solicit people to go file suit against him, and they were offering to pay them because they offered these people, one person was offered $1,000, the other person was offered $10,000, all for them to go and say that Buzbee misrepresented them. And this was what Rock Nation was out there doing. And so here we are today. As you know, Jay-Z was named. Oh, I'm pointing in the wrong direction. It's this way. My bad. It's this way. Yes, it's this way. Okay. Because I had to look at myself on camera because I had to see what was going on. All right. So y'all know that Jay-Z was named in this Jane Doe case. Okay. He was not originally named in the Jane Doe case, but he has since been named. And I'm going to say I have not sipped not one glass of my wine, but cheers to y'all and let's drink to this. All right. Because we about to get into it. All right. So what I am drinking tonight is Yellowtail Jimmy Red Rue. I believe this used to be Sweet Red Rue. It is a sweet red wine. Now, this document right here was filed on the 26th, which was today. Okay. And it's 53 pages. Well, no, it's 5 pages. I'm sorry. It's document 53 and it's pages 1 through 5. So we're going to get into this right here. Okay. And we're going to read. We ain't going to read all of this, but we're going to get into the remaining motions. Like, we gonna get into that because that's what y'all gonna want to hear. So let's get into this document, baby, and refresh y'all. So it says Annalise Torres, who is the district judge, is presiding over this case right now, and this is out of the United States District Court, Southern District of New York, which is the federal house where Diddy's case is currently being housed at. Okay. And yes, I said his case is being housed. That don't come from me. All right. So plaintiff John Doe filed this action on October 20th of 2024, alleging violation of New York City Victims of Gender Motion Violence Protection Act. Okay. On December 8th of 2024, and yes, we are skipping through because we don't need all the fluff information. On December 8th of 2024, plaintiff amended her complaint to add Sean Carter, known professionally as Jay-Z, as a defendant. Plaintiff again sought leave to proceed anonymously, but this time Carter's counsel appeared and moved to deny her motion, or in the alternative, to dismiss her amended complaint pursuant to Federal Rule of Civil Procedure. Carter also moved for an expedited hearing on the issue. The next day, Carter's attorney filed a letter containing a declaration from an association at his law firm recounting a phone conversation she had with an unnamed woman who claimed that the plaintiff's counsel encouraged her to lie about her experience of sexual assault. Now, remember, we read that letter already. So if you are just catching up to this, I guess I'm going to have to take some time to sit and put all of the Jay-Z Buzbee stuff into one playlist so that y'all can go ahead and catch up on it. But we did read that lawsuit already, where this woman stepped forward and said that she was being trafficked by other celebrities. And she also said that allegedly, when she called the Buzbee firm, they were trying to encourage her to include Diddy into her case. Allegedly. And so when she decided that she was not going to add Diddy into her case because she had never met him, never been trafficked by him, allegedly, that the Buzbee firm then said to her that they were not going to take her case, and then they dropped her as a client. Allegedly. So we don't know if any of that is true or not, which is why I keep hitting the allegedly, because it's all alleged, right? So we read that document already. So it says Carter's lawyers asked the court to consider this additional information in connection with plaintiff's motion to proceed anonymously. Plaintiff's counsel denied Carter's allegations against him. And on December 13th, 2024, Carter's attorney filed an additional letter alerting the court to recently published interview of the plaintiff on NBC's News. Okay, remember, we went over that already, where the woman came out and she was anonymous in the news broadcast. So we covered that as well. Okay, and it says in the interview, the plaintiff spoke anonymously, explaining her allegations against defendants and her reasons for coming forward. Carter's lawyers pointed to the interview in which the plaintiff admits to inconsistencies in her story as evidence that the plaintiff's claims had no factual basis whatsoever. He also argues that the plaintiff's claims have no factual base whatsoever. He also argues that the plaintiff's counsel violated the Federal Rule and Civil Procedure 11B by failing to undertake a reasonable inquiry into the facts before filing a complaint and failing to seek an admission. Carter's attorney requested an expedited briefing schedule for a motion to strike the First Amendment complaint under Federal Rules, Civil Procedure 11C2, ... Right? So we went over all of this. So remember, they've been going back and forth, right? They've been going back and forth, back and forth, back and forth. So the next day, Carter's counsel submitted yet another filing and a motion for an emergency order directing the preservation of evidence and striking the amended complaint under the same rule, right? Child, and we sip. Hold on. We gonna sip right now. Now, motion to proceed anonymously. In deciding whether a plaintiff may proceed anonymously, courts balance the plaintiff's interest in an amnesty against both the public interest in disclosure and any prejudice to the defendant. Okay, the Second Circuit has laid out a non-exhaustive list of factors to be considered. So the factors to be considered are whether the litigation involves matters that are highly sensitive and personal in nature, whether identification poses a risk of retaliatory physical or mental harm to the party, which I believe it would if she came out and showed herself, okay? Whether identification presents other harms and the likely severity of those harms, including whether the injury litigation against would be incurred as a result of the disclosure. So it's whether there's going to be any type of injury, okay? Whether the plaintiff is particularly vulnerable to the possible harms of disclosure, which I believe she would be, okay? Whether the suit is challenging the actions of the government or that of private parties, whether the defendant is prejudiced by allowing the plaintiff to press her claims anonymously. Okay, so whether the plaintiff's identity has thus far been kept confidential, which it has, whether the public's interest in the litigation is further by requiring a plaintiff to disclose their identity, whether because of the pure legal nature of the issues presented or otherwise, there is a typically weak public interest in knowing litigations, or whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. All right. So it says a court is not required to list each of the factors or use any particular formulation as long as it is clear that the court balanced the interest at stake in reaching its conclusion. Here, the weight of the factors tips in favor of allowing plaintiff to remain anonymous, at least for this stage of litigation. So the judge said at this point in time, there's no need for us to force her to say a damn thing. We're going to allow her to keep her herself anonymous, and let's keep the party going. Let me sit. Child, this is going to be an interesting live. Let's take a pause for a second. Thank you, Pretty Ginger, for that super chat. Thank you, Jamie, for this super sticker as well. Jamie is a heavy supporter of the Henny Gang, and I appreciate you so very, very much, okay? So it says factors 1, 2, and 4, and 7 weigh strongly in favor of this plaintiff basically staying anonymous, all right? In her amended complaint, oh, let me switch my screen so y'all can see me. I'm shit. I wasn't even sharing the document to y'all. Y'all ain't even know it. That's fine, because we on the document now. We're going to hit that Zoom one time so y'all can see where I'm at one time for the one time. In her amended complaint, the plaintiff alleges that defendants rugged and raped her when she was only 13, okay? And the sexual assaults are highly sensitive and of extreme personal nature, okay? Plaintiff is particularly vulnerable to the possible harms of disclosure. According to her amended complaint, she continues to experience depression, post-traumatic stress disorder, and seizure disorders associated with the stress of her sexual assault, okay? Moreover, plaintiff's counsel asserts that many of his other clients who have filed similar lawsuits against Sean Combs claim to have been threatened by Mr. Combs for their decision to speak out. And finally, although plaintiff sat for an interview with NBC News concerning her case, NBC allowed her to conduct the interview anonymously. Judge is not playing. She said, baby girl done went already out there. And they publicly allowed her to be anonymous. It says, granted, several factors weigh against allowing plaintiff to proceed anonymously. Plaintiff is challenging the actions of private parties, not the government. And given the media attention surrounding this case, the public has a substantial interest in this litigation, separate and apart from its general interest in accused being able to publicly confront the accuser. So basically, they're like, listen, you trying to let the accuser publicly confront her, but we don't have to allow that to happen. Okay. Most importantly, plaintiff continued anonymously, amnesty may cause prejudice to defendant, making it more difficult for them to collect the facts necessary to mount a defense and, as appropriate, challenge the plaintiff's credibility. So they are basically not going to allow this factor right now. So it says, nevertheless, at this exceedingly early stage in this case, the factors counseling against disclosure outweigh those that counsel counsel in favor. So basically, all of the factors here outweigh his need to be able to know who she is. protecting her is more important than that. Okay. So accordingly, the plaintiff's motion to proceed anonymously is granted. Period. I'm just saying, this is crazy. Plaintiff is advised that because the balance of these factors will contain shifts at this case as this case proceeds, especially if and when the parties engage in discovery in earnest, the court intends to revisit this decision at a further date. So in a later time, in a later date, they'll revisit this as to whether or not she can continue to go anonymously. All right. So as to the remaining motions, since Carter's attorney first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer, many of them expounding on purported urgency. Okay. So it says, describing plaintiff's counsel as willingly to blatantly violate the core ethical obligations of all attorneys and requesting a hearing. Carter's lawyers relentlessly filing of combative motions containing inflammatory language and attacks is inappropriate and a waste of judicial resources and a tactic unlikely to benefit his client. She said, all you doing is wasting the court's time. That's what she's saying. All y'all doing is filing all this paperwork and you wasting the court's time, okay? The court will not fast track the judicial process merely because counsel demands to. So you wasting our time, you filing all these inappropriate documents and motions, and you demanding that we fast track this. Boy, who you think you playing with? It goes on to say, moreover, although Carter's attorney assails plaintiff's lawyer as having a chronic inability to follow the rules, Carter's counsel has also failed. Carter's counsel has failed to abide by this court's clear rules. So you saying that he is not following the rules, but Alex Spiro, you yourself are not following the rules either. Interesting. Although Carter's attorney stated that he intended to file immediately a motion to strike the First Amendment complaint under the rule, okay, he did not give the plaintiff the required 5 days to respond. Individual practices wait for the court to set a motion schedule or state whether this is unacceptable. Okay, counsel is hereby advised that any further motions filed in violation of this court's individual proceedings may be declined on that ground alone. So you filing and playing dirty, and based off of those grounds and those grounds alone, you file another motion up in this court, and it will possibly be denied. Lastly, although Carter's attorney is entitled to file a Rule 11 motion without first seeking leave of court, the court discourages this approach. If he still intends to serve plaintiff with a motion for sanctions, the court denies his request to shorten the safe harbor provisions contained in Rule 11C tip. Carter's motion to strike the amended complaint under Rule 12F is denied. By January 10th, 2025, plaintiff shall file her request to Carter's motion for an order directing preservation of evidence. By January 17th, 2025, Carter shall file his reply, if any. It is so ordered. This judge said, Alex Spiro, I ain't playing with you. You up in this court and you wasting taxpayer dollars, you wasting my time, and you wasting paper. And I'm not going to play with you not near another time. You file another motion if you want to, and depending on how I feel that day, it may be denied. And we sip That Henny burning going down. That ain't even Henny, that's wine. Listen, Linda. I told y'all that this case between Buzbee and Jay-Z, this was going to be entertaining. We're going to keep you up to date because as of this letter filed today, there's been nothing else. Okay, let's see what's going to happen. She said that they have until January 10th and 17th. So we will continue to check back with this case and let you know what all the hot Henny is on that one. So we are going to move it right along. Okay. Now, this next case that I'm going to bring to you is a case that we've covered as well. And I have not given you an update on this case since. I wish I had a drum roll. Can y'all hear this? Because I got to find it because I thought I found it. But I was playing around with y'all over there on IG and I forgot to pull it up. So now I got to go and pull it up right now as we speak. But either way it goes, y'all should know who we about to talk about if you was paying attention to what I said in the beginning. Because what I said in the beginning was who we was going to be talking about. And I'm still trying to find who we're supposed to be talking about, but I can't seem to find him. And I know he's in here. All right. So basically what I'm trying to do is, okay, I found him. So okay, so this is not the first time that we have spoken about this person, but forget it because this is not going to be pertaining to anything that is of importance anyway. So let me go ahead. Girl. The next person we going to call down into the people's courts, I need to get that song. This is DJ Akademiks case, okay, against the girl Sophia Abril, or whatever her name is. I can't even, the Sophia girl, okay. And this is the one where it was like Big AJ and Little Boom. Remember the girl that went viral because she was calling him out? Yeah, this is that case, okay. So remember that we did go over this case sometime in October, okay. To refresh your memory, if you don't remember, this is the young lady that he called over to his house in Jersey, and he had her get there in an Uber. And while she was there, she was rugged
allegedly,
and she was raped
allegedly,
by his friends
allegedly,
who ran a choo-choo on her.
allegedly.
And then when DJ Ack woke up, he went into the room and he then began to essay her.
Allegedly.
And he was trying to get her booty, y'all.
Allegedly.
So this is that case. All right. So since this case, as you can see here, this is last dated October 21st, 2024. And it was him trying to basically get this case pushed back. This case has not been thrown out. However, this other girl, he has been pulling a flim flam and a flume flume on her because as of December 18th, wait a minute, I got to see. Which way am I pointing? Am I pointing this way? No, I'm pointing this way. Leave me alone, okay? So, as of December 18th, this is the update on this case. So it says, please take note that date and time as soon as thereafter counsel may be heard, plaintiff by and through her attorneys, T.A. Blackburn Law, PL shall appear before the Superior Court of New Jersey, Law Division in Essex County at court located at and the address, okay? So they will be moving forward with appearing at court, okay? But now here goes this. This matter having been brought before the court by plaintiff, I don't know how to say, Miss Abasi. Oh, Abasi is the one. Abasi is the one that had the choo-choo done to her.
Allegedly.
While she was rugged.
Allegedly.
So yeah, The other girls, the Sophia girl, that's the girl who says that she was brought out and was supposed to be paid. Well, this Sophia case, okay, as of it says, I'm sorry, y'all. He just think he a dog, like he need a doggy door and want to be going in and out all night long. Okay. So basically, what is happening with this case is DJ Akademiks is trying to get this case held off on. Okay. He's not trying to show up to court. He's trying to push it back. Okay. Respondent raises a myriad of arguments in his brief addressing both the adequate and appellate argument and the lower court's decision to grant respondent leave to file an answer to an underlying complaint. 3 respondents' points, however, warrant failure. Okay. First, respondent misconstrues New York's law so to require attempted services on the defendant's place of employment in order to satisfy due diligence required. Second, contrary to respondent's construction of his own actions, respondent is squarely liable under New York rights law and proffers. Okay. Contrary to the respondent's analysis and appellate complaints, the court is urged to read the respondent's bare bones affidavit. It is important to emphasize that he, 1, admits to having the court papers for the last several days before appearing in this matter. 2, admits to the place of service was his correct residence. 3, does not provide any detail as to where his place of employment may be. 4, does not deny certain allegations. 5, admits that he does not check his mail. This is when DJ Akademiks, if you don't remember, he admitted that he did find the paperwork while he was out walking his dog. Let me see if that's in the video. Oh, I didn't get a chance to pull up the video. Okay, so there are DJ Akademiks videos where I broke down this case already, and we read through the court docs, and he was saying that he was never served. By the time he found the information, he found it somewhere on his property while he was walking his dog. So what they're saying in this letter is basically like, hey, he's admitted that it was the right address. He's admitted that he received the paperwork. So what are we here for? What are we talking about? Okay. Where was I reading from? This is the Sophia case, okay? At best demonstrates his own lack of diligence in his everyday affairs, or at worst lacks complete credibility and should be disregarded. So they're saying that just because he said, now we're in the Sophia case, not the Abasi case. We're reading the Sophia case. So basically what they're saying is because he was asking for more time in the Sophia case as well. So in this Sophia case, what they're saying is just because this ninja says that he did not receive the mail does not mean that he did not receive the mail, because he's admitted that he found it. He's admitted that he also does not check his mail every day because he said that. And he's also admitted that when he received it within time. So why are we even giving him any more time? Okay. Respondent misconstrues the holding of the law firm to overemphasize attempting service at the defendant's place of employment. Specifically, the Second Department of Palazzo determined that the plaintiff's process service did not exercise due diligence. The 3 attempts to make service of the summons and complaint on Dr. Monaco's at his residence on different days of the week. Wait a minute. I lost myself. That's wait. I know what it is. Sorry, y'all. Hold on one second. That's what it is. They're reading these cases. That's what those little, because I'm like, wait a minute, what the hell? I done confused my damn self. Maybe I need to put this damn wine down, because they're talking about cases that are related, that show reasons as to why academics should be given more time in that case. Now it's back in October, but I'm still kind of curious as to why academics still there's been no movement on that. He's still trying to get a default judgment vacated in her case. And he wants it vacated because he attempted to serve her 3 times. That's what it is. He attempted to serve her 3 times. So he's asking for a motion to vacate. That's what's going on in that case. Okay. Now, in the Abasi case, he's ignoring them. So now this lawyer is applying pressure in the Abasi case. The girl that came from came from Philly to Jersey. He's ignoring the hell out of them. He's not responding. Now, I'm curious as to why this Sophia girl has not been able to be served. But I'm not going to hold you. I'm not judging her. I'm not saying that what she's alleged is not true. What I am going to say is, I kind of felt that case was a little shaky from the gate, but this Abasi one, I believe it. I believe it. 100% I believe it. I don't think it's shaky. Anyway, it says that compelling defendants to provide full and complete response to the plaintiff's discovery demands. That's 1. 2, striking defendants' answer and defenses and entering default judgment against defendants for failure to comply with their discovery obligations. So he has not adhered did I say that right? Adhered to his discovery obligations at all in this case. All right. Please take further notice that in support of this motion, plaintiff shall rely upon a certificate of Tyrone A. Blackburn, Esquire, the attached exhibits, and the accompanying legal brief, which are filed conspicuously. Please take notice that a proposed form of order is submitted to the court's evidence. And please take notice that oral argument is requested in opposition if opposition is filed. All right. So that's the certification of the mailings. So then we go down to here, and it says this matter having been brought before the courts by plaintiff Abasi. I don't know how to say her name. I just know it's Abasi. Through her counsel, Tyrone Blackburn, which you should know that name, Tyrone Blackburn, because he was taking on all of those Diddy cases at one point in time, okay? By way of motion to compel discovery, or in the alternative to strike defendant's answer and enter default judgment, and the court having considered the submissions of the parties, the arguments of the counsel, and for good cause shown, it is on this date and month 2024 ordered as discovery compliance. Defendants are hereby ordered to provide full and complete responses to the plaintiff's discovery demands, including interrogatories, requests for production of documents, and deposition notices within 5 days of the date of this order. So Mr. Blackburn is telling DJ Akademiks and his law team, you got 5 days from the date of this letter. And hold on, let's see, what is the date of this letter? This was filed on the 18th. The date of this letter, December 17th. So he's got 5 days from the 17th. Let's look at it. Let me look at a calendar real quick. 17th. 1, 2, 3, 4. Ooh. Okay, so if we not counting the weekends, and we not counting Christmas, we not counting Christmas, yesterday made the 5 days, and today would be on the 6th day. So his time is up. Wait, I meant to do it. His time is up. So we're going to have to come looking. We're going to have to come looking back, okay? Because they gave him 5 days from the date of the letter. Not from the date of the filing. 5 days of the date of this order, from the order. So this order is in. Now, if they want to count, it wasn't filed on the 17th. It wasn't filed to the 18th. It expired today. So it's going to be interesting to see what happens in the next 24 hours or what happens between Monday and Tuesday. All right, sanctions for non-compliance. Should defendant fail to comply with the terms of this order within the specified time, defendant's answer and defenses shall be stricken. So anything that he tries to answer in his defense will be struck from the record. Okay, default judgment shall be entered against the defendants as to liability. So now you were about to lose your bread. You were about to lose the bread. Hit this dance, y'all. You were about to lose your bread. Hey, I'm sorry. I'm sipping and I'm feeling really good today. Anyway, attorney fees and costs. The plaintiff is awarded responsible attorney's fees and costs incurring in bringing this motion. Plaintiff's counsel shall submit an affidavit of fees and costs within 5 days of the date of this order for the court's review and approval. Oral argument. The court heard oral argument on this matter and it doesn't have a date, and consider the position of all parties. Further relief. The court retains jurisdiction over this matter and reserves the right to impose additional sanctions or grant further relief as deemed appropriate. Okay? I, Tyrone Blackburn, of full age, duly sworn. I am the attorney. He's an attorney licensed to practice and yada, yada, yada. That's what all of that is. Okay. So basically, they have been trying to get in touch, like I said, with DJ Akademiks, and he has been wholeheartedly and purposefully ignoring them. So let's see what happens, because if she gets a default judgment, it's over. It's over. Move over now. Which to me, if I were DJ Akademiks, I had put myself into a situation like this, and I knew that if I publicly admitted that this stuff went down at my house, or there was a possibility, because I know the type of character of people that I hang around. Let me just take this off for a second because we're having a moment. If I were Akademiks, I wouldn't show up to court and I would let this go to default as well. Because by letting it go to default, there's no record of me owning up to any type of omission of guilt. I have not shown up to court to say whether I am innocent or guilty. And if I let this fall into default, it's never on record as to whether I was innocent or guilty. And being that I have already put on a court record that I did not receive the letter in my mailbox and that it was thrown about somewhere on my lawn and I didn't discover it until I walked my dog, I already have something that I could feed to the public to tell them, oh, these paperworks were coming to my house and I wasn't getting them. I don't know where they went, chat. Chat, listen, let me tell you. I don't know nothing about this. I wasn't getting it in my mail. I already told them that it was coming in my box. So how she got a default judgment is beyond me. But you know what? I got money. It's nothing. Did I sound a little bit like him? Did I give a little bit? Anyway. So I feel like that is just his play and his ploy right now, because this way he still keeps his endorsements. He doesn't lose anything that would continue to generate his money. And he never had to go before the judge or in a court of law to say whether or not he was guilty or whether or not he was innocent. So I think that that's the play that's being moved and run right here. And that's probably a play that was put into motion by his mentor, the person who guides him into all of the shady that he does. This dude right here. Oh, three-finger duty shooter himself. Probably told him, just let it go into default. I told him not to do that. I told him don't go in the court. I told him it's only a couple $1,000. You could afford that. I told him. Anyway, while he's out here saying I told him games. Y'all remember this case right here? Bring y'all back up to speed. So let me remind you. Jaron Harrison is the one that brought up this federal this RICO case on him out in Michigan. Now, since the last time that I brought y'all that video, which is linked down in the description below, where y'all can go back and watch the whole video where I go through all of the court docs from beginning to end on this case, and y'all can get all of the juicy details on it. His case has been accepted into the United States District Court, Eastern District of Michigan. Okay. And it is an acknowledgement of receipts of documents. Okay. Order directing service, reservice dated 9/26/2024, 16 copies of complaint. Okay. And this document is dated October 11th, 2024. And it is stamped. October 18th, 2024, United States Marshal Service. There's their signature of stamp. Okay. And I want y'all to look. Radar, which obviously is one of Ray J's companies, was served. Okay. Then you have 17 Inc. That was also served. You also have the Tronics Network that was also served. You have Raycon, the Norwood Kids Foundation. First round knockout. Let me just say this. Him proclaiming his innocence to the world is not the same as him proclaiming his innocence in a court of law, because he was brought up on charges of sexual assault against a female who he brought to his home and was too drunk to remember that she was even coming. He brought that woman to his home. Therefore, he was responsible for her from the minute that he put her in that Uber ride to his house. When she got to his house, she was sexually assaulted. Allegedly, by his two friends. Okay. She was rugged and assaulted, and then was later assaulted by him. Allegedly. So therefore, if you really want to clear your name up, you would have went into court if you were innocent and cleared your name. But he's not going into court to clear his name. And sometimes not saying anything, sometimes not following up with things is an omission of guilt. Now, that is if he has not responded to this stuff. Again, today, if they're counting the 18th as the motion being filed, today would make the 5 days, which means that between this time, between the 18th and today, his lawyer, he had time to contact his lawyer. And I'm sorry, if you sitting on a couple of bands, you shouldn't want to lose any of your bands, because your reputation means more than money. Money comes and goes, but your name, once it's got smut on it, will have a question on it forever. And I'm not attacking you. I'm just giving you my thoughts on what your comment said. Let's continue. Now, Publishing Inc. was served. Rajon Kajon, Raytronics Inc., Sonia Norwood, William R. Norwood Jr., which we know to be Ray J. Now, what I'm going through right now in this video right here is all of the people who were served in the Jared Harrison case. This is not Jared Milgram. This is Jared Harrison or Harris. He's the one who brought Wack up on Wack and Ray J to this to a federal level in Michigan because of the fact that they were hacking his accounts and all types of things to him. So this is the federal hacking case. Sorry. Knockout Entertainment Inc. again. Ray J Touring Inc. R&B Productions Inc. I'm not sure who this is to, but I will dig and get back to you. All right. Oh, I didn't find that one. You also have Norwood and Norwood Inc., Kathy Freud, and of course, Cash McElroy Jones. Now, the reason why I played that portion of this video is because those are all of the people that were served. Okay. These people were served. He sent out what he was supposed to send out to them. All right. Hold on one second, y'all. because I want to make sure I have this in order. Okay. So, what document is this? Does it say? It says page 59. Hold on one second before I pull these documents up, because two of these documents are kind of similar, but they're not the same. So I don't want to confuse you, and I don't want to confuse myself on this. But yes, let's see. F9. Document 59. Okay, so what came first? 49 comes first. So let's go to document 49. Why is it not showing? There it goes. Okay, there's a little bit of a delay. All right, so this is part. Okay, so right here, this says eBay Company Inc. to pay $3 million in connection with corporate cyber stalking campaign targeting Massachusetts couple. So this is a link. Okay, it says this part of Exhibit E was re-uploaded because after downloading from docket entry, I noticed this link did not pull up when I clicked on it. And I also noticed the link from Exhibit F were completely removed and changed, but the original document used to upload works just fine. Here goes directly the linked destination to view the content. All right, so he's saying that this is basically the same thing that's going on in his case, because he's hitting them with cyber stalking and bullying, okay? This is in alignment with what I've been experiencing for the last couple of years in my business, as mentioned in the complaint. If the court would request evidence and proof, I can provide it. Am I glitching to y'all? Because I'm glitching to me. Okay, so it's a slight delay. Uh-oh, y'all. All right, so this is Exhibit F, where he quotes Ray J from his recent interview that he did with Pastor Jamal Bryant. And he quoted him saying, "I'm a liar unless I say these people did this to me. They're very bad people and they've been controlling me this whole time." Now, who do you think Ray J is referring to when he says this? Because the first person that came to mind was old three-finger duty shooter himself. Why am I glitching? This is pissing me off. I don't like it. But anyway, we're going to continue with the content. In this video link above, Willie R. Norwood Jr., a.k.a. William R. Norwood Jr., a.k.a. Ray J, sits down with Pastor Jamal Harrison Bryant on his podcast and opens up about his life, saying he wants to come back to church, but the same sentiment. He calls out Pastor Jamal Bryant before the interview airs and tells him not to post the interview because of something he said that could hurt him legally. Now, we all remember Ray J crashing out before this interview hit the air, okay? He then went on to say, if you post the interview, somebody getting snatched out of the pulpit. During this interview, defendant went on to say, "I'm a liar. I've lied about my whole life." The plaintiff, Mr. Harrison, believes some of the things said in this video is referring to this legal suit he has with Mr. Harrison. And defendant may have said some incriminating things that could and would hurt his defense. The video was edited at Mr. Norwood's request to fit what he is comfortable with the world seeing. The plaintiff, Mr. Harrison, will request the full unedited version be subpoenaed for more evidence on top of what he already has. So Jaron, listen, there's two J words here. There's Jaron Milgram and Jaron Harrison. So the two J's, it's really messing me up right here right now. I'm not going to lie to y'all. Plus, I'm sipping a little bit, so you know. So he's going to subpoena the unedited version of that video. He better hope they still have that unedited version, because I would like to know too. The link above shows how Ray J threatens Jamal Bryant with being snatched out of the pulpit in fear of the full interview airing. All right. I'm trying to see if it's looking bad on y'all end like it is on mine. The video link shows defendant William R. Norwood Jr., aka, okay, it just shows Ray J, saying that the judicial system is rigged and that even if you're telling the truth and they're telling a lie, that the lawyer will find loopholes to try and get you out of the situation. Now, I remember when he said that. And I felt like this man done lost his mind. That's exactly what the defendant's counsel is attempting to do here now. While knowing the truth of the evidence submitted, the defense counsel, insurance provider, and displayed here in the docket entries A through F, other documents. Uh-oh. Okay. Wait a minute. Sorry. All right. So that's the last document from that one. Now we go to document number, if this is the correct one. Nope, this one right here. So it says defendant's response in opposition to plaintiff's motion to oppose defendant's motion to dismiss pursuant to, and those are the codes. Now, if you remember the last video I brought y'all, what does it say? It's glitching a little. Okay. As long as it's a little, but you guys can still understand what I'm saying, then I'm cool with it. Maybe if I stop moving, it won't glitch as much. So let me just sit here very still. They have put in a motion to dismiss the case, okay? Let me see something. I think this document comes first. Hold on. Okay, boom. So we're going to go here first. So this was their response to him, okay? So the introduction, the lawsuit, we read all of this already before, if you remember, okay? It says, I'm trying to get to where it says, the court does not have personal jurisdiction. So this was all that they filed in here, okay? It says on December 1st, 2024, plaintiffs filed a instant motion and request in opposition to defendant's motion to dismiss, both of which functions as a response to defendant's motion to dismiss, whether the plaintiffs do not seek concurrence in their motion. If they had, defendants would have informed them that the instant motion is improper and unnecessary because of its duplicative duplicative child, listen, response accordingly for the reasons set forth herein and in the defendant's motion to dismiss and reply in support thereof. The plaintiff's motion should be rejected in its entirety. So what they're saying is that the plaintiff failed to comply with local rule 7.1a. Plaintiff's motion should be denied in its entirety for failure to comply with local rule 7.1a, which requires a moving party to seek concurrence prior to the filing of the motion, okay? We're going to go through their motions and then his response. If you want to see a full breakdown of this part right here, you got to go to the previous video that I did. All right. Then they go on to say that the court does not have personal jurisdiction over the defendants. So because this was filed in the state of Michigan, and Ray J and Wack and Sonia and all of those corporate entities that he named in this lawsuit are all in California, he's saying that their lawyer is saying that they don't have jurisdiction over them, so that this should not move forward in court, okay? And these are their reasons for dismissing. Plaintiff failed to state a claim upon which relief could be granted, is another one that they put in there. And in conclusion, they want them to hurry up and dismiss this. Now, I like him. I like Jaron Harrison. You know why I like Jaron Harrison? Because he's not letting them bully him into the long kiss goodnight. He's not having it. All right. So he went on ahead and put in a motion for a default judgment. Can y'all understand me? Because I know I'm glitching. and I keep looking over because I'm looking at my phone to see how bad it is on y'all end. Because I'm sorry, y'all. If I gotta redo this video, I'll redo this video if it's glitching really badly. Okay. But as of the 20th of December, let me go back to this one. When was this one filed? Okay, so if you look at the top of this document, it says that it was filed on 12/13/2024. Okay, so that was when they filed theirs. So now here come Jaron Harrison with his motion on the 20th. Baby. So he's going for a motion of default judgment. So plaintiff Jaron Harrison, by and through their undersigned counsel, respectfully moves this court for an entry of default judgment against defendants Willie R. Norwood, Ray J. Basically, this motion is based on the following grounds. Okay, defendant's failure to timely serve plaintiff by mail. So remember in the video that I sent y'all, he had already sent out all of the mailings. The only person's mailing that did not come back, it was Wax that did not come back to him, and I think like 2 other businesses that did not come back to him. Okay, so it says defendant is required to serve an answer or motion within 21 days after being served with the summons and complaint, which in this case was on or before November 25th of 2024. Okay, any motion or response filed must also be served to the opposing party. So any motion that they decided to do or anything that they decided to file should have been served to him as well as the courts. Okay, the defendant filed a request with this court by the November 25th, 2024 deadline, but did not serve the plaintiff by mail at the address listed on the summons by the same deadline. So what he's saying is, while they submitted paperwork to the court, they did not follow proper procedure and protocol by making sure that he was served as well. Clerk's repeated denial of default. The plaintiff previously requested the clerk of courts to enter a default against the defendant based on this failure to timely serve the plaintiff by mail. However, the clerk denied the request on multiple occasions. The clerk initially informed the plaintiff that the defendant had until the end of the day on November 25th, 2024 to file and serve the response. Subsequently, the clerk altered the necessary document for requesting the clerk's entry of default without proper acknowledgement of the defendant's failure to meet both the filing and service requirements. So it sounds like some buffoonery and foolery is going on. Did somebody get a wad of bands in their hands and them bands will make her dance every time? I don't know. Okay. On the most recent occasion, the clerk acknowledged that the defendant had submitted the request to the court by the deadline, but failed to address the fact that the defendant did not serve the plaintiff by the same deadline at the address listed on the summons. So they're acknowledging, the clerk acknowledged, like, yes, he did. They did file this. However, they failed to service it to you as well. The demand amount was also charged from $40 million to $40K, then to $4 million after repeated calls to the clerk's office requesting they change it back to $40 million. It was the $40 million that it was originally. So they've also been messing around with what his amount is that he's been demanding. He's demanding 40 M's, y'all. I say give it to him. Defendants admitting of mailing on deadline date. In their own motion, defendant acknowledged that they mailed their response to the plaintiff's address on November 25th, 2024, the deadline date. It is important to note that Rule 12 of the Federal Rules of Civil Procedure Service must be completed by the deadline, not simply mailed on the deadline. The defendant's own admission confirms that they failed to comply with this critical requirement, okay? The defendant urges PACER system served plaintiff. The plaintiff is pro se and does not use CM ECF system reserved for attorneys So the plaintiff never received notification of filing, considering the plaintiff uses pro se upload via Eastern District of Michigan's website homepage to submit filings and a Pacer case search account where he pays 10 cents per page to view filings. Even if that was the case, it is still not proper service processed as listed and stated on the summons that defendants must respond to the court and serve the plaintiff response or motion at the address listed on the summons. So he's saying, look, even though they filed this stuff in the court of law, regardless to whether I can go look this up or pull it up online, it doesn't matter. It still was supposed to come to me. So because it didn't come to me, they still had not followed proper protocol or procedure. The defendant's counsel Jason Canvasser, has repeatedly and consistently attempted to intimidate and deceive the plaintiff via not allowing the plaintiff to respond when attempting to confer on phone calls, by trying to tell the plaintiff what he is going to do and how the plaintiff should respond to it, indicating that the defendant's counsel believes because the plaintiff is pro se and not an attorney, that he can manipulate the plaintiff in favor of his clients getting out of his case via dismissal. So he's saying, I've even talked to their counsel, okay, because I'm representing myself, and he's trying to swindle me. He's thinking he could pull a fast one on me because I'm not counsel. When the plaintiff doesn't agree with what he's saying, he simply overtalks and ends the call quickly, then says he attempted to confer, when in fact what he did was attempt to manipulate and deceive the plaintiff. And I am so glad that he is putting this on the record and is standing up for himself, because he is basically putting it out there saying that, look, their lawyer is trying to bamboozle me, and I'm not having it. For that reason, the plaintiff would follow up every phone call to confer with email. He also is attempting to manipulate the court by filing his entry number 58 and 59, where the defendant counsel goes on to state, defendants timely filed their motions to dismiss and serve the plaintiffs accordingly. Defendant Norwood, Sonia Knockout Entertainment, Ray J Touring were not served until Sunday, November 2nd. Therefore, defendants had until Monday, November 25th to answer the otherwise plead. Okay, defendants Radar, First Round, Knockout, and Tronics TV were not served until November 15th. Thus, they had until December 6, 2024 to answer or otherwise plead. Further, Rajon, Kajon Inc. and 17 Inc. were not served until November 25th, and they had until December 16th to answer or otherwise plead. This is 100% false, as the docket entry number 10 titled Acknowledgement from the U.S. Marshal Service of Receipt of Service of Processing Documents forms with tracking numbers in the remarks section. Each tracking number verified that on November 2nd, all defendants counsel represents were served properly at the addresses listed on the summons. That is the video that I was playing ahead of this document. So what they're trying to say is, they're trying to say that each entity did not receive the documents on the same day. They're giving you different dates. So they're saying that because we received it on this date, we have until this date. And because this wasn't received by this entity until this date, they have this date. And that's not true. They were all served on the same day, at basically according to the receipts that were provided and filed to the court on record. Can you say dummy move? Sheesh. Okay. It also says that a certificate of service was then posted on civil docs via ECF, and return green cards arrived. That is what defendants counsel is attempting to deceive the court. That is proper service of process as it pertains to correctly correctly serving response of plaintiff by the deadline. So they basically have no reason to say that they didn't have enough time, because they had plenty of time. Given the defendant's failure to timely serve the plaintiff by the deadline, the plaintiff respectfully requests that this court enter a default judgment in favor of the plaintiff. Okay. He goes on to say, under Rule 55 of the Federal Rule of Civil Procedure, default judgment is appropriate where a party has failed to plea or otherwise defend by deadline. 11/25/2024, as required by federal rules of civil procedure. Okay, a party who files a document with a court is required to serve a copy of that document to the opposing party or their attorney by mail. Service is generally considered complete when mailed. Wherefore, the plaintiff respectfully requests that this court enter a default judgment against the defendants pursuant to Rule 55 of the Federal Rule of Civil Procedures, grant relief in the sum of $40 million or any further relief the court deems appropriate. Respectfully, Jaron Harrison. Baby, let me tell you something. Now that's how you bully the bully. That's how you fight back. Okay? That's how you fight back. I'm sorry, I was looking at some of y'all comments. That's how you clap back at them, okay? So now this was filed on the 20th, which was 6 days ago. So Jaron is looking for his $40 million default judgment, baby. Wack is quiet on this matter. Ray J's freaking out over this matter. But I'm here to tell you, the party is still rolling on. Cheers to you, Jaron, because that salute to you. Mm-hmm. Y'all be sure y'all getting them likes up. I'm finna open my panel after this. Y'all better jump up on this panel and tell me what y'all thinking, how y'all feeling, what's going on in the world and what y'all thinking. All right. Now we're going to move it right on along to the one that everybody has been asking me about. Okay, people have been asking me, wearing me out and wearing me down in the inbox. Then y'all went after one of the Henny Gang members that y'all know sits very close to me. And it wasn't Selena. Let me just make sure that y'all know it was not Selena. But y'all been hitting up a particular person that's part of the Henny Gang that I don't know if they still in here or not, asking them about old Blueface and what's going on with his case. Now, I'm feeling like I should have waited to do whacking them last because, I mean, Blueface got all of these he got all these civil matters going on. So let's take a little looky-loo. I ain't got no more windows open, so I don't even know what's going on here. Let me close this, and let me close this, and let me close that. It looked like I'm frozen. Okay, I was frozen for a second. Now let me go ahead and let me share this. Is it me or is YouTube acting up? YouTube is acting up for me. You're buffering. YouTube acting up. If I have to redo this video, I'm gonna be mad. You hear me just fine? Okay, as long as you hear me just fine. So let me play this video for y'all. Here, let me go here. Let me go on and then here. All right. So y'all remember this? I'm going to make this big. Okay, so basically what I was trying to show you there, but it's being real like we can hear you. It's just freezing here and there. Now it's stuck. We can't see it. Okay, so let me do this. Let me do this. Let me do this. Maybe this. Okay, so I'm going to turn my camera off. Since y'all can hear me just fine, I'm going to turn my camera off. Because I know it's a bit of a distraction to be looking at me on camera and I'm freezing up. It stopped now. Now y'all can hear me. Henny Glasses in the chat. If my sound, y'all said my audio was good. So let me just come on off the camera and let's just deal with the documents. All right. So if y'all remember, this is this Jackie? Is this Jackie's case? Yes. This is Jacqueline Martinez's case. All right. Jacqueline Martinez is Soulja Boy's baby mama. And if y'all don't remember, Soulja Boy's baby mama, this says to the clerk on December 22nd, 2023. Okay. She says, I request the court judgment under Code of Civil Procedure, Section 585B, 585C, 989, etc., against the defendant, Jonathan Jamal Porter. So she's asking for a default judgment to be entered in against him. And if you remember, she is asking for $2,016,373.10. Okay. So she's moving forward as of, like I said, this was just this month, December 22nd, a couple of days ago. Oh, no, I'm sorry. That was from last year. That's when she filed it. She's asking for a default judgment on him. And so her memorandums have also come up to $2,173 on top of that. There has not been any other movement on her case as of right now. And he was served at all of his addresses. Okay. Now, we're going to go on over here to the Kentavious trailer. Now, if you remember, Kentavious trailer is the dude that was pow-powed in the hand in the nightclub incident, okay? And this was filed on May 22nd of 2024, all right? And it's saying that the court stated in order to show cause due to the lack of activity in the case. Upon the court's inquiry, Mr. Cox stated he filed their notice of appearance yesterday, advised that he was unaware this case was filed as they were going to file a new suit. Mr. Cox added that they seek default judgment on one of the defendants, which while it was his understanding, they settled with the other defendant. Request time in order to speak with his client to prepare an order for dismissal for Euphoric Gentlemen's Club. Now, Euphoric Gentlemen's Club is where all of that comes. It says the court ordered show cause is vacated. So the Euphoric Gentlemen's Club already settled their portion of the lawsuit that they had with Kentavious Trailer. Now that just leaves Blueface's side, right? Well, I'm gonna close out these windows as I go along too. When we get down to this case, you see right here that it says Euphoric Gentlemen's Club, right? And then right underneath that, it says Jonathan Jamal Porter, Blueface. Okay, default judgment. All right. This default judgment was entered on August 24th of 2024. Okay. And it says default against defendant Jonathan Jamal Porter, aka Blueface. It appearing from the files and records in the above entitled action that defendant Jonathan Porter, aka Blueface, being duly served with the summons and complaint on October 2nd of 2023, that more than 21 days exclusively of the day of service have expired since service upon the defendant, that no answer or other appearance having been filed and no further time having been granted, the default of defendant Blueface for failing to answer to the complaints is hereby entered. So that's when he entered in his default judgment for him not hearing back from him, right? Okay, so then we move on to this right here. And this is Jarvis Hurd versus Kentavious Trailer. Now, Jarvis is the gentleman whose car, oh, you can't see that. Hold on one second. I got y'all. Boom. Okay. Now, Jarvis Hurd is the guy whose car was hit when the pow pow happened in the parking lot, right? Here we have all of the journal entries. The journal entries go as follows. They had the jury trial. They had the discovery check. A status check for discovery was on April 17th of 2025. And this gentleman, Mr. Hurd, Jarvis Hurd, is not only suing Kentavious Trailer, but Kentavious Trailer is at the top of the lawsuit. Blueface is also connected to this lawsuit as well. He was suing the both of them because he said his car was totaled. Okay. So on April 17th, they had their discovery. On December 19th of 2025, there was a status check for trial readiness. And then they have a pre-trial conference coming up on February 19th of 2016. And then they have the pre-trial memo that is scheduled for February 27th of 2016, a calendar call that is happening in 26, y'all. You're not about to trip me up. This right here says April 17th of 2025. This says December 19th of 2025 was their status check for trial readiness, and their pre-trial memo, their calendar call, and the jury trial is all not happening until 2026, starting in February. They will not be going to jury trial until March of 2026. No, right there where I highlighted, y'all. Y'all see it. It says 2026. Now, why it's pushed out so far, I have no idea. But it says 2026. I've been on a few channels. When you're telling the truth about CS2 back, channels always have difficulties, never fails. It's true. Every time I talk about him or any of his people, I always have issues with my lives. But now that is the case with Blueface and Kentavious Trailer. Okay. So now let's move on. Y'all know nothing is happening until 2026 with that case. Dang it. Now let's go here and let's go to the scheduling of the trial. All right. Jarvis Hurd and Kentavious Trailer. All right. Oh, this is the same case. Okay. So as y'all can see, nothing is happening. Nothing is moving. Nothing is moving, guys. As far as his probation goes, he still has probation. What? Why did I just get a thing pop up on my screen that says Google Chrome would like to record this computer screen and audio? What? Why would my Google Chrome want to record this? You know what? Denied. I don't know you. Ain't that about a blip? Anyway. Now, this Jarvis Hurd dude, right? He wants to enter a motion of default for Jonathan Jamal Porter. And the reason he wants to enter a default is because he's not appearing. It appears from the files and records in the above entitled action that defendant Blueface, being duly served with a copy of the summons and complaint by the 14th day of December 2023, that no answer or other appearance having been filed and no further time having been granted, the default of the above named third-party defendant for failing to answer or otherwise plead third-party plaintiff's summons. So you have both of these people right here. Jarvis Hurd, okay, the dude whose car was smashed during the incident, okay, and Kentavious Taylor, Trailer, the dude who was pow-powed in the hand. Both of them have entered default judgments on Blueface, okay? I declare under penalty of perjury. All right. So it's saying that he was served. But here's the thing. They're serving him at his home and he's incarcerated. So it's going to be interesting to see how that actually plays out. Now, my question to all of this is, if he is being represented by CS2 back, aka three finger duty in the shoot, three fingers in the duty shoot, is supposed to be representing him, then how is it that his client is in so much legal trouble as far as civil matters go? Because all of these civil matters are not a matter of just a couple of $1,000s. Y'all see, a Soldier Boy's baby mama want $2 million. He still has the lien on his home that hasn't gone anywhere. And y'all could check the previous video I did on this, the last video I did on this, where he's got what, a $14-15 million lien on his home. Then you add the $2 million from Soldier Boy's baby mama. That's $17 million. Excuse me, $17 million right there. But you supposed to be legally, you supposed to be his manager. Why you not managing? You all up in his personal business. He want to get up here and talk about his woman and talk about his child. But you can't handle his personal lawsuits. But his personal business is good enough to be spread all across the internet for content, though, right? Child. Or is it that he too busy worrying about his lawsuits that he got coming against him because he about to lose his bread? Anyway, I said that I was going to open up the panel, but being that YouTube is acting up and I see myself, I'm still kind of glitchy, I think we're going to end it right there. Now, I'm going to keep up with what's going on with Buzbee and Jay-Z, because this is interesting to watch, because the judge, she ain't having it with none of Alex Spiro's little games that he be playing in his shenanigans, because he's shenaned and he's going to shenan again. Also, DJ Akademiks, you about to lose your bread, honey. Everybody's losing bread. Child, it looks like he got a default judgment that's possibly coming against him, but we're going to see exactly what happens if there was any response that was made, because like I said, today was the deadline for that. Also, we're going to keep up with what's going on with Jaron Harrison, because he's saying, look, they trying to play and I'm not about to play with them. I want my 40 M's, so run me my money. And then you got Blueface, who has these civil suits, these civil matters where everybody is asking for a default judgment. Soulja Boy baby mama is putting him in default. The kid that got pow-powed in the head, well, I can say it now. We are an hour and a half in. The kid that got shot in the hand is asking for a default judgment. And the guy whose car got crashed in the mist trying to escape the shootout that was happening at Euphoric nightclub is asking for a default judgment. So everything is going into default. And he still has a lien on his house. And when he comes out of the state prison, that bid that he's doing right now, he still has probation in I was going to say Texas, child. He still is going to have probation in Las Vegas. And he's probably going to be on parole. So this is going to be interesting to see. But this has been your Celebrity Court Doc recap and the update on all of the celebrities that y'all all love to hate, for real. Anyway, if you have a court case or a court doc that you would like us to look into, please be sure to either hit me up or hit up Henny Snipers Media on IG. If you stayed here from the beginning to now, I appreciate all of the support. Listen, y'all said y'all wanted me to. I'm not drinking wine on camera no more. This not happening. I didn't finish my glass. At least not this glass. But thank you for staying and tuning in and rocking out with your girl. It has been wonderful spending time and space with y'all. When y'all rest, be sure to rest well. Shout out to the replay game, because y'all be running it up. Salute to all of y'all that have been in the chat. I love y'all and I appreciate all of the support, and I will see y'all in the next video. Peace, y'all. Now let's see if my outro is going to play today. Because I don't want